A decision maker and an assessor looking at a PIPP claim will compare and contrast how the person manages the activities that they're claiming to have difficulties with within their PIPP claim versus what they're doing in those other roles.
What the assessors tend to do is say, okay, so you've had bad days 10 days a month, the other 20 days you are absolutely fine and don't have any limitations at all, because the form doesn't explain what the limitations are on those less bad days.
My name's Chris, this is my colleague Kat. Between us, we're both senior lawyers and directors at PIPP Information Non-Profit. Between us, we've got experience in PIPP of over 15 years, and we currently deal with all aspects of PIPP, starting from initial forms all the way through to the appeal process. With the appeal process, our success rate is currently 98%. So the topics that we're going to cover today include what PIPP is, the eligibility for PIPP, and how PIPP is scored, as well as how the application process works and the application forms, and how to challenge the decision. Excuse me. So let's start with what is PIPP. As of January of this year, 2026, there are approximately 3.85 million PIPP claimants just across England and Wales. PIPP is a disability benefit for those who are eligible, who are aged between the ages of 16 and state pension age. For anybody who is under the age of 16, the comparable benefit is Child Disability Living Allowance, also known as Child DLS. For anybody over state pension age, who is not already in receipt of PIPP, the comparable benefit would be attendance allowance. If the person's already in receipt of PIPP, they can carry on with that PIPP claim as long as that PIPP claim doesn't end. PIPP is a disability benefit that is not means tested. So what that means is that a person can work, they can study, they can have caring obligations for other people and still make a PIPP claim successfully. National statistics suggest that around 15 to 18% of claimants across England and Wales are currently working. However, from our experience and the claimants that we help, we actually believe that that figure could be much higher. It is worth, however, mentioning that whilst a claimant can do those things, they can work, they can study, they can have caring responsibilities, a decision maker and an assessor looking at a PIPP claim will compare and contrast how the person manages the activities that they're claiming to have difficulties with within their PIPP claim versus what they're doing in those other roles. For example, if a person uses a mouse and keyboard at work, if a person does knitting, if a person plays a musical instrument, all of these things would generally suggest that a person has a fairly good level of dexterity. Therefore, an assessor might say that that person doesn't have any difficulty or has limited difficulties with chopping and peeling fruit. So it's very important to clearly describe and explain how a person struggles and the limitations and the adjustments that they have in place in order to manage the things that they are managing versus the things that they're not managing. PIPP is based on 12 different activities. The first 10 of the activities, are based for daily living, and the other 2 are based on mobility. In terms of daily living, the first activity is that of preparing food. So this is looking at a person's ability to stand for long enough to prepare a simple meal, their ability to chop and peel food, including their ability to grip, for example, to hold a knife or a peeler, their motivation to complete the task, and then cognitive abilities to manage the processes of that task. The second one being taking nutrition. So that's looking at a claimant's ability to cut up food that is on their plate, transfer and convey that food to their mouths, chew that food and swallow that food. Again, also looking at their cognitive abilities and mentality in doing that task. We then move on to managing therapy and monitoring a health condition. That's looking at a claimant's ability to manage their medications and any therapies that they need to do at home. It generally considers memory, motivation, and dexterity in relation to that task. After that, we look at a person's ability to wash and bathe. So this is looking at a claimant's ability to stand for long enough to shower, get in and out of a bathtub or a shower, and their ability to wash both their upper body, their lower body. Again, also looking at their cognitive abilities to manage that task and their motivation to do so. We then look at their ability to manage toilet needs. And this is an activity that, due to its personal nature, we often find people tell us they have no problems with. But upon some further questioning and some further investigation, we realise that people do actually have problems with this activity, even if they don't initially realise it. This doesn't consider their ability to travel to and from the bathroom, but it does look at their ability to get on and off the toilet, clean themselves after using the toilet, and if they are suffering of incontinence, how they would manage that. We then move to dressing and undressing, which is based on how a person manages to dress and undress both their upper body and their lower body, as well as managing fasteners such as zips, buttons, and bra straps. We then move to two quite narrow descriptors, we call them. And that's the first one of those is communicating verbally. So this is looking at a person's ability to form words with their mouth and their ability to hear. It is very difficult to score any points in this activity. However, somebody with a hearing aid or speech impairment can in some cases score points here. A lot of people think that they should score points here, but in reality their points should be actually awarded and engaging with other people, which is another activity further on. The second of the narrow activities is reading and understanding signs and symbols. This is looking at a person's ability to understand what we call a simple sentence and a complex sentence. As an example of a simple sentence, can I have a cup of tea, please? A complex sentence, as an example, can I have a cup of tea with 2 sugars, please? There's not much difference. The way the DWP describe complex sentences is not necessarily what we might think of in natural language. We're looking here at a person's ability to manage even if they have prescription glasses. Things like registered sight impairment should also be considered. We then move to engaging with other people face to face. This looks at a person's ability to manage in a social environment on a one-on-one basis, not necessarily a group setting. However, there is case law that suggests a simple ability to manage in a work environment doesn't necessarily mean that that person doesn't score points. They can still manage in a work environment and struggle in a social environment and get some points in certain cases. And the last of the daily living activities is making budgeting decisions. So this is looking at how a person would manage their general household finances, things like accessing their own bank account and their own information, but also the difficulties that they struggle with. A person with sight difficulties who struggles to read their own bills and their own letters can sometimes get some points here in certain cases. That's the 10 daily living activities. We then have 2 mobility activities. The first one being planning and following the journey. So that looks at a person's ability to manage this process cognitively. So this is the ability to both plan the journey before leaving the house and follow that journey when they leave the house. But this does not actually consider their physical limitations in walking, but the cognitive ability to do so if they could walk that hypothetical situation. Claimants with seizures, sight issues, hearing difficulties, and cognitive impairments can all score points under this activity. And the second mobility activity is moving around. So that's the physical activity of putting one foot in front of the other to walk around. We're not, however, looking at a person's ability to walk from the start of their journey to the end, but simply from where they start to when they first need to take a pause or a break, be that due to fatigue, breathlessness, pain, or any other reason. I'm now going to hand over to Kat, who's now going to move on and discuss eligibility.
Hi everyone. Just to pick up on something that Chris did mention there, with the 2 descriptors that we are quite narrow, which are communicating and reading and understanding, if a claimant is registered sight impaired or hearing impaired, they should automatically entitle them to points in those areas. I say should because DWP don't always do it. Okay, eligibility. So as Chris mentioned, PIPPS for anyone from age 16 to state pension age. It's not means tested. It's intended for anyone who's got a long-term physical or mental health condition or disability and who can manage those PIP activities that we just mentioned without some form of help. For the purposes of PIP, long-term means the claimant must have had the condition for 3 months before the decision, and it must be expected to last for 9 months afterwards. Conditions don't have to be formally diagnosed, but claims made without some evidence of the symptoms are unlikely to be successful. Claims can be made before that 3-month qualifying period ends, but payments will only begin once that period's been met. It's known as the required period. In most cases, the claimant must be limited in managing those activities for at least half of the days within that 12-month period I've just mentioned. So they don't need to have difficulty managing them every day, as long as they do have difficulty managing them most days. So, for example, if a claimant can only prepare a meal 2 or 3 times a week, and they're unable to do so the other 4 or 5 days, they would be classed as unable to complete the activity because they're unable to do it for at least half of the days. One of the big issues that we see most often is when people complete their own forms or their assessments based on their worst days. Unless those worst days are half of the time or more, then what the assessors tend to do is say, okay, so you've had bad days 10 days a month. The other 20 days, you are absolutely fine and don't have any limitations at all, because the form doesn't explain what the limitations are on those less bad days. So what we always say is address both within your forms, your assessments, and if it goes on to be an MR, and your MRs. So make sure you're addressing those less bad days and the really, really bad days. The reality is somebody might be bone-bound on the worst days, but most days they can hobble to the toilet, they can sit down and make a sandwich, and it's those most days that matter. And it's just important to bear that in mind, that they're looking at those most days throughout the entire process. Next slide. Okay, so there's something called star conditions. So to be considered able to complete an activity, a claimant must be able to do so reliably, which means meeting these 4 conditions that are on the screen. Safely means completing an activity in a way that's unlikely to cause severe harm to either the claimant or another person during the activity or afterwards. In a timely manner. This is outlined in the law, and it explains that a claimant shouldn't take more than twice as long to complete an activity compared to someone without that impairment. So an example here might be somebody that's really breathless and exhausted while they're washing and dressing, and it takes them 2 hours to get washed and dressed on a morning. That's much longer than it would take somebody that may not have that condition. Somebody that can prepare a meal, but they maybe got OCD, they have formalised rituals, so they take all morning to prepare one meal. It's taking them more than twice as long. The third one is to an acceptable standard. This doesn't actually have a precise legal definition, but what it means is completing an activity to a standard that's good enough for it to be okay. And finally, repeatedly. This means completing an activity as often as is reasonably required. So, for example, a person might be able to prepare a breakfast, but once they've prepared the breakfast, the exertion leaves them so exhausted that they can't prepare any lunch. By the evening, they might have recovered enough and they might be able to prepare a meal again, but they've missed a meal out of the day. So they haven't been able to perform that activity with the required number of times in a day. Similarly, somebody with mobility issues might be able to meet the moving around criteria on one day. That might be the day they can go to the supermarket. But the exertion of doing so and the pain that that's caused means that the 3 or 4 days afterwards, they're not walking anywhere. So they're not managing to mobilise for more than any distance most days of the week. So it's important to consider these star conditions when looking at any PIP claim. Chris showed you earlier the different activities that PIPPS scored on, and you can see that they make up 2 components. So as Chris explained, the first is the daily living component. This relates to the person's ability to look after themselves, keep themselves safe, and manage the self-care tasks. The other is the mobility component, which focuses on a person's ability to go out and their ability to walk. Within each component, there are 2 possible rates of benefit. The first is standard and the second is enhanced. To receive standard daily living, they must score 8 points across the 10 daily living activities, and for enhanced, it's 12. Similarly, for mobility, a claimant needs 8 points for standard mobility and 12 for enhanced across the 2 mobilities. What's important to remember here is that if a claimant meets more than one descriptor within the same activity, they only receive the points for the highest scoring descriptor. So, for example, if somebody needs an aid to prepare food because they can't stand for long enough to prepare a meal, that's worth 2 points. But then they're also having seizures. That's worth 4 points because they need supervision. They wouldn't receive 6 points, the 2 plus 4, they would just receive the 4. What's really important to remember is that the way PIPP is scored is not based on what the claimant actually does in real life, but how they manage some hypothetical scenarios that are defined in legislation and case law. So it's really important to have a look at what that form's asking you, not what you actually do in real life. So, for example, as Chris mentioned, for preparing food, the question that it's asking is, can you prepare a simple meal for one person? They're not looking at if you can manage to prepare a meal for your family, which of course is what many of us might do. Okay, next slide, please, Chris. Thank you. The claimant journey. We've popped this in here because I believe that the slides are going to be shared late afterwards. And this I had this flow chart that we've created, and it explains the different steps in a PIPP claim, each of which Chris is going to go through shortly. But you can always refer back to that at a later point if you need to. Thanks, Chris.
Thank you. Okay, so let's move on to the ways that a person can apply for PIPP. To start the claim, this can be done in one of several different ways. It can be done by writing to the DWP. It can be done online in some areas of the country on the Gov website, and it can be done by phoning the DWP. Generally, if the online service is available to you, we recommend that is the quickest, fastest, and easiest way to do this. Alternatively, we would recommend phoning the DWP to start the process. If somebody struggles with a phone call, you can have somebody else, or the claimant can have somebody else make that call, but the claimant will need to be present to pass data protection to start with and authorise for the other person to speak on their behalf. We don't recommend writing to the DWP to start a claim, and I'll tell you why. If you write to the DWP to start a claim, it's not actually the DWP that opens their post. DWP post for PIPP goes to a handling centre in Wolverhampton. It used to be managed by staff from Royal Mail. It's now managed by an alternative private company. Although they do receive training by the DWP in relation to PIPP, they are not caseworkers, they are not case handlers, they don't know the PIPP process. And it relies on them understanding what the letter is that you've sent to PIPP and ticking the right box to start the claim. If that's not done, that letter will just get filed on the system and nothing will happen with it. Somebody will be sat there months later wondering why they've not heard anything, and it's because simply it's on the system and nothing's been done. And then the person's left with either writing to the DWP again, or reverting back to the phone call which could have started the process in the first place. The other reason we don't recommend it is because when you do a claim yourself online, or when you speak to somebody on the phone, a number of pieces of information will be gathered at that point. That information includes contact details, nationality and residency, payment details such as bank accounts, as well as details of doctors and medical professionals that are involved. The DWP do need this information, so if you just write to the DWP, if they are able to process it, and if you are rookie enough to actually have them understand what you've said to them, they will send you a form called a PIPP1 form in the post, which you're going to have to complete and return, which is adding an additional step to the process which would have already been done if you'd have done it by phone or online. It is worth noting that although I have just said the DWP do collect medical professional and GP details, it is incredibly, incredibly rare that they will ever contact any one of those medical professionals. And even if they do contact those medical professionals, they ask for a factual information. They simply send out a letter that got predefined questions on it to those medical professionals, and generally speaking, the information that it's sent back is one line from that medical professional that doesn't actually give the DWP any useful information. So it's Really, really important that during the claim process, a claimant provides evidence themselves. Don't rely on the DWP collecting that for them. Once the eligibility checks have been done, in basically through that phone call, the online process, or that PIP1 form, a claimant gets sent a PIP2 form, also known as a How Your Disability Affects You form, and we're going to have a look shortly at how that gets completed. So let's do that now. PIP2 forms can either be sent out as a paper form, which the person can complete, either on the form or as an additional Word document, and send it with the form, and they then post that back to the DWP. Or if a person is familiar with computers and has access to email, it can be done in an online format. All of these forms do have an expected return date, generally 4 weeks after it was sent, in which the claimant must complete the form and send it back to the DWP. 4 weeks is not a lot of time to put in sufficient detail in these forms, so a claimant can phone the DWP or have somebody do it for them, providing they will then pass data protection and request more time. Generally speaking, they will allow 2 to 3 extensions of up to 4 weeks at a time, so you can get more time than what's given. If you have got a paper form, it is really important that even if you've typed up your answers or written them on a separate paper, to send that original form back, because that contains what we call smart code on the form, that when it gets received, the system automatically recognizes that that form has been returned. Now, if you are going to send in an additional paperwork because you've completed the form in a separate document, or if you've just gone over in pages and you've written it on the form and then added further pages, always write C continuation sheets or C attached paperwork on the actual form to make that clear to the DWP, and make sure that form is signed as well. Anything that gets posted to the DWP, such as that postal form, always send it tracked postage. I know that they do send out a free envelope for return when they send you paperwork. Don't use the free envelope, send it tracked, and I'll tell you why. What the DWP have a habit of doing is scanning documents in, they don't get attached to the system correctly, nothing happens to it, and then eventually you speak to the DWP to chase it up, and they say, sorry, we've not received it. The funny thing is, as soon as you are able to provide a tracking number to them, they can see all posts that came in. They will be able to search that tracking number out of the system, and a couple of minutes later, they will magically have found the documents that they've told you they've not received. It is vital to keep documents tracked. As Kat has already mentioned earlier, it's really important that the forms are completed based on how a person is managing the majority of the time, that 50% of the time or more, not basing the form on a person's worst days or a person's best days. One of the examples of how a form can be completed, I'm going to give you an example sentence here. I'm unable to stamp and prepare and that is not great. However, if you were to say, I'm unable to stand and prepare a meal on most days because I have a balance, that adds context to the reasoning why. Any single limitation that you're mentioning on a PIP form, explain the context, explain the reason for that limitation. The more relevant detail you can put on a form, the better your chances are of having a successful claim in the first place, or if you're challenging a decision, the more chance you have of challenging that decision. Okay. The 50% rule is clearly laid out in legislation, and we have put the link on the slides there, which, as we say, we'll send out afterwards if anybody wants to go and check out that legislation there. Now, if a person has successfully made a claim, eventually that claim will have an end date that will be told to the person based on their limitations upon the notification of the successful claim. After that, a review process is triggered automatically, and we have a PIP review called an AR1 form. Alternatively, if somebody is in the middle of a claim and they have a change in their circumstances that they report to the PIPPIN, they would have a change of circumstances, which would generally also be the AR1 form. It is really important to note that if you are going to report a change to the DWP, you must have had that change take effect for at least 3 months prior to reporting an change. That brings back down to the eligibility rules that Kat mentioned earlier, of a situation being in place for 3 months before and the following 9 months, to total 12 months. The exception to this is if a person has already got the enhanced rate of both daily living and mobility, and then their condition worsens, you're not going to get anything by reporting that change. You still need to tell them about it when you come to the review process. However, it's not going to change the award unless you've got better, in which case you do legally have to tell them that you've gotten better. But don't fall into a trap that a lot of people do, which is telling them they've gotten better when they've had one good day. You need to have that consecutively before you do, because that will trigger the review process. In relation to review forms, one of the things that we often see is people saying no change, or only noting down the bits that have actually changed in their claim. That loses people awards in those situations. A review form, even if you've had a successful claim, has to have the same level of detail as a brand new application form, because it's not guaranteed that assessors or decision makers will look back at that previous claim form. Again, same rules apply. If you're posting it to the DWP, send it tracked. It is possible for people to have longer awards. Generally speaking, they're called 10-year awards or light touch awards, light touch reviews. That means that the DWP do still review the claim, but they generally do so in the background with a much shorter form called an AR2 form being sent to the claimant. That is generally for people who have chronic lifelong conditions with little to no prospect of success. In most cases, after a light touch review, the award will stay the same or increase. It is very rare for a light touch review to result in an award being decreased or removed. As I mentioned earlier, in relation to completing forms, there is a deadline on the form, be that an online form or a paper form, generally 4 weeks. Always request an extension to that if that is needed, if you're not going to be able to get that form back within that 4 weeks. Purely because if you've done and you already got an active claim, that claim will stop. Or if you haven't got an active claim, your application will be stopped at that point because you haven't completed the form that's added to them and you haven't contacted them about it. If somebody is very near a deadline and they cannot get an extension, they've contacted the DWP, they've been told now, hang up and call the DWP again. Because it does really depend on how well trained the advisor is that you speak to, and if that person's having a good day, to be perfectly honest with you. Countless times we hear people, they tell us, they message us and they say, I phoned the DWP, they've said no to me. Our first bit of advice is exactly what I've just said, phone them again. Speak to somebody different, and 9 times out of 10 they'll message us back a couple of hours later saying, I've just spoken to somebody else, it was a completely different experience, and I've got the extension that I've just asked for. If the answer is still no, sign that form, write C continuation sheets on it, and post it to the DWP as it is. And here's why. Once the form is posted to the DWP, it takes them quite a number of weeks. At the minute, for a new claim, we're seeing a couple of months. For a review form, we're currently seeing anything up to about a year for them to process it. During that time, you can still submit further information and further evidence. Post it to the DWP so it's logged on their system as received, and then get the actual information on a separate document along with the evidence sent in as soon as possible after that. Again, and I know I've already said this, and I really cannot stress this enough, so I know I'm being repetitive in saying this, send it tracked. I honestly cannot stress that enough. So what do you need to send with a form? Well, you need to send evidence that supports your claim, which Kat is going to talk to you about now.
Thank you. As Chris mentioned earlier, the forms, all of them do start by asking for details of your GP and any other medical professionals. And it lulls people into a false sense of security. People think, I've given them my doctor's details, they are going to contact my doctors. They do not. They only contact somebody's doctor if they have already decided that that person is vulnerable and that they are unlikely to be able to provide their own evidence. The proportion of people that they do that for is tiny. It's less than 10%. It's probably even less than that, I bet. It's the onus is on the claimant to provide any evidence on which they want to rely. So we popped a list on the screen of good evidence of the sort of things that you can consider. What a lot of people will say is, should I ask a doctor or a medical professional to write a letter? If that's going to cost you some money, the answer is no. We'll see letters sometimes from GP that will say, I think that my patient is eligible for PIPP because they cannot work. Well, PIPP isn't an absence of work benefit, so that's absolutely no use. Doesn't address any of the activities. And they'll charge the patient £100 for it. It's unnecessary. So what we suggest is go to your GP surgery and ask for a subject access request. So that's a data protection request for all of the information that they hold on file for you for the last couple of years. It'll come through and it'll be, a chunk of paperwork, and sift through it and see what evidence you have already got. There's probably likely to be things in there you've not seen. For example, internal referrals between doctors. So if you're referred from one department to another, Dr. A will write to Dr. B. You will never have seen that letter, but it will probably have a list of your symptoms on it, which will generally be really, really good evidence. You might have other evidence in there that talks about things like problems with your grip or problems with mobilising, and maybe your GP's referred you to physio and it says this person can't walk for 50 metres. Fantastic for the purposes of PIPP. So look what you've already got. Just be aware that when you put a subject access request into your GP surgery, the GP acts as a central hub. So you might be bored up to talk to my GP, but I see lots of other medical professionals. Every time you see a medical professional, generally, they will write to your GP. So there'll be a whole bank of letters that you've probably never seen. And the evidence that already exists tends to hold more weight than evidence that you might have gone to ask your GP to write. One of the other things we see when GPs write a letter is that they will put, the claimant tells me they cannot mobilise for more than 20 metres. PIPP will pay absolutely no attention to that because all the doctor's saying is what you've told the doctor to say, which isn't a medical opinion. And they'll still charge you £100 for it. So just be aware of falling into that trap. If somebody does want to provide a supporting letter for you and they're not going to charge you, then what I'd suggest doing is actually going through the PIPP descriptors with them, the PIPP activities, and explaining how you struggle and why you struggle. Generally, just a one-paragraph letter isn't much use. The other things that are usually really, really helpful that I do just want to outline here out of our list and that are worth in the waiting gold are occupational therapy reports or adult social services reports and care plans. If you are a person that has any of those things, that sort of evidence is phenomenal for PIPP. Okay, Chris, you want to pop up to the next slide? Thank you. Okay, so once you've returned your form and you've waited, 6 months to 18 months for your assessment, you'll then be sent for an assessment. Almost all claimants need an assessment, and these days, since COVID, these can be by way of either a telephone call, a video link, or they can be face-to-face. It is possible for a claimant to have an assessment done purely based on the papers. Around 50% of the forms that our team complete result in a paper-based assessment, but that's because we know what the criteria is and we are directly addressing every point that they need to know within our forms. It's very rare that a claimant themselves deal directly with DWP or take a paper-based assessment. The format of the assessment really doesn't matter. We find that results generally are the same. However, if you're given an assessment that doesn't suit you, so for example, you're given face-to-face, but you're a person that can't get to a face-to-face assessment for whatever reason, can't leave the house, you've got mental health problems, you can't do public transport, all you need to do is give them a call and say, I've been given a face-to-face assessment, please can I change it to a video assessment or a telephone assessment? And we're stakeholders with the assessment providers. They have promised us that they will allow people to do that. What can also be changed is the time or date of an assessment. However, it's important to remember that these assessments can only be changed one time. So you can call to make a change to the format and or the time and date once. So just make sure you make that call if you're changing it from face-to-face to video, and you also want to change the date. You've only got that one opportunity to do so. So make sure that the time and format that you change it to that one time, you can stick to. Assessments themselves are undertaken by third-party organisations. They aren't undertaken by the DWP themselves. At the moment, these are Capita, Igenis and Serco, and that's decided by postcode area that you live in. We have POTS, I think there's a link at the end, is there, to the checker, where you can see who it's going to be. But the reality is it doesn't matter which assessment provider it is, they're all pretty much the same. The assessor themselves will be either an OT, a nurse, a physio, or a paramedic, all of who have to be members of their own regulatory bodies. So they do all have to have some sort of medical qualification. Unfortunately, they don't look at the case before allocating the case to an assessor to allocate the best professional for a job. So, for example, we might see that an OT, or we might be of the opinion that an OT would be best to assess somebody that's got something like hypermobility. And a mental health nurse would be best to assess somebody that's got learning difficulties, for example. However, for PIPP, they don't think of it like that, and the next available assessor just gets the next case on the list, which often isn't suitable. It often means that the assessor isn't suited to the best claimant. And a claimant can have a companion with them at an assessment, and we do encourage them always to do so. Never go to a PIPP assessment or attend a PIPP assessment without somebody with you. It can be a friend or a family member, and they're known as a companion, or you can have somebody professional in a similar ilk to the sort of work that we do that's known as an advocate. If it's a telephone or video assessment, they don't need to be with the claimants physically, and they can be dialed into the call. But if it's a face-to-face assessment, they have to go with them in person. You can't have an advocate or a companion dialed into a face-to-face assessment. One of the things we hear a lot, and this isn't in our notes, but is recording. Should I record my assessment? We suggest no, for a really good reason. There is absolutely nothing you can do with that recording once you have it, apart from listen to it for your own purposes. So if you record the assessment, and you can legally record an assessment without getting their permission, however, you cannot then share that recording with anybody because it is a breach of the Data Protection Act. What you can do is have it transcribed, but there is quite a significant cost to having something independently transcribed. And the reality is that once you've got past the next stage, which is the decision, nobody actually wants to nobody wants to actually listen to that assessment. You're not going to get a tribunal panel that has an hour and a half to listen to what was and wasn't said at your assessment. A tribunal and a mandatory reconsideration decision maker effectively are more interested in, should you have had the points? And if so, medically, why should you have had those points? Often people will say to us, my assessor lied, this told something that wasn't true. And when we look at the assessment report, what that person means is the opinion that the assessor has come to, for example, that somebody maybe can walk 50 metres when they can't, that's their opinion. It's not necessarily an outright lie. So there's no way of proving that anyway on the call. If you have somebody with you at your assessment, they can make notes, and those notes can be helpful because you can obviously submit those in paper format if you do an MR or an appeal. Okay, next slide, please. Okay, when an assessor has assessed you, they will write a report, or they're writing it as they're assessing you actually. This is known as a PA4 report if you have a telephone, video, or a face-to-face assessment. Although the rare paper-based assessments, the report is called a PA3 report. The assessor will write it and usually send it to DWP in the days after the assessment. And then often they'll send the claimant a text message to say, we sent the DWP a copy of your report. And this report is what the DWP decision maker uses to make their decision. What we always recommend is when they get that text message to say the report's gone to DWP, or when it's about 7 days after an assessment, they call the PIPP inquiry line and they say, please can I have a copy of my PA4 report, just for my records? And they'll post it out to you in the post. And when that arrives, it's about 25, 30 pages usually. And what that will have is that will have a breakdown of every point they have suggested that you are awarded. And of course, this puts you on the front foot if that decision or those points are not what you'd wanted. You're then not waiting 6 to 8 weeks for your decision to come through. You already know what you're likely to be awarded from that assessment report. And if it isn't what you want, of course, then you can start making moves to see what you need to do next. Next slide, please, Chris. Thank you. Once DWP have had the report and they processed it, it goes to a claim manager at DWP. This is the person that is not medically or legally qualified. They are simply a person that works in the office that decides whether to award you points. They'll then send a decision notice out to you which will explain where you have got the points. And if the decision is not what you want, it will state towards the back pages that you have a month to do something about appealing that decision. This is actually incorrect. You don't have a month, you have 13 months. The law states in the legislation that a claimant has the 1 month that the letter allows, and in addition, they have an additional 12 months if they have a reason for asking for more time. And of course, as a person with a disability, the reason for asking for more time is literally, I have a disability. I needed more time to submit this. The number of people we get coming into contact with us that say, and in the last few days of my 1 month period, and as soon as we reassure them that they do not have 1 month, they have 13 months, it gives them all the time in the world then to move on to the next part of the process, which is the MR. And I'll hand over to Chris, who'll tell you about that process.
Thank you. So, if you disagree with a decision, a person can do what we call an MR, or a mandatory reconsideration. Now, a mandatory reconsideration is set out within the legislation as the next step in challenging the decision if you're not happy with the outcome. What is it? So, the first part is it's asking the DWP to reconsider the decision, and as the name would suggest, it is mandatory. You cannot continue with any other form of dispute, such as an appeal, if you have not undertaken the mandatory reconsideration process. In terms of processing the mandatory reconsideration, these can be done in a couple of different ways. Again, you can phone the DWP and ask them for mandatory reconsideration. They will take down some information from you on the phone about, dropped through in that. They will take down some information on the phone about why you disagree with the decision. You can complete a form online, however, you do have to print it off and post it after you've completed it. You can't submit it online. Or you can simply use a Word document or a pen and paper to write a mandatory reconsideration. You don't have to use a square form if you don't want to. If you are going to use the form that is available online, the boxes on that form are quite small. They don't give a lot of space for detail. So if you are going to use it, be prepared to add additional papers to give you a level of detail as to why you actually disagree with it. And if you are going to disagree with the decision, always be clear about what it is that you disagree with. Use that assessment report that you requested a copy of. Pick up on all of the points that the assessor has mentioned and made that you do not think are correct, and explain why you don't think those points are correct. And also put on there what you think you should have been awarded and why. Include every aspect of the disability and the limitation that you are reporting. Now, as I said, you can do this by phone. However, a court handler at the DWP is going to give you a couple of minutes for you to give information. They're going to note it down loosely, probably not in that much detail, and generally speaking, the success rate for mandatory reconsiderations done by phone is generally the lowest. Always do it in writing, either on the form or in a separate document. Post it to the DWP. Once you've posted it to the DWP, again, do a chat, and it gets lodged on their system. They should send you a text message that says, hey, we've received your mandatory reconsideration process. We will process it. They generally give a time limit in that text message of how long it's going to take them to process that mandatory reconsideration. Take that time limit with a pinch of salt, because generally speaking, the DWP are not good at sticking to time limits, and it will probably be at least a couple of weeks, if not more, past that deadline that they give in the text message. If you've posted a mandatory reconsideration to the DWP, you've seen the tracking on the postage details that it's been delivered, and a couple of weeks later you've not heard anything, you've not had that text message, you've not had that confirmation, give them that phone call and say, hey, I'll send you a mandatory reconsideration, I want to check that it's been logged on your system. And make sure that they confirm to you on the phone that it is logged. Otherwise, it falls back into that trap of been sitting on the system and nothing happening with it. Once the DWP have reviewed the information, they may in some circumstances make a phone call to yourself, to the claimant, and ask for some clarification on any points that they need to double check. That's perfectly normal, and if that happens, it is generally only quite a short phone call with just a couple of questions for them to clarify. Once they've made a decision on it, they will send a new decision letter called an MRN, Mandatory Reconsideration Notice, which details the outcome of that. And in that, they could have changed the award, either to what you've asked it to be, they could have changed it to an alternative level, that's maybe less than you asked for, but still better than what you'd originally had, or they may have stuck with the decision that it was in the first place. As Kat has said, a claimant does have 13 months by law in which to submit a mandatory reconsideration, as long as you've got a reason, that being that you've got disability. And I have included on the slide with the legislation that confirms that. Unfortunately, around a third of mandatory reconsiderations are successful, which means 2/3 are generally unsuccessful. Generally speaking, with a claim that's not successful, the next step is going to be an appeal, which we're going to discuss in a moment. That figure of it being about 30 is based on the year of 2024 to 2025. We're still waiting for the updated statistics on that at the moment. However, looking at a longer period of time, we generally see that it's about 33% of mandatory reconsiderations in the last 5 years that have been successful. It is worth noting that if the DWP do make contact to discuss anything about a mandatory reconsideration, the calls generally do come either without warning, or they send warning by a text message a couple of hours or a couple of minutes before that call takes place. So what we do suggest is, if you do need more time, do ask them to give you a call back. Generally speaking, as long as you get a helpful person on the event, they will arrange another time to call back, but they will only do so either later that day or the following day in most cases. But we do suggest keeping a photo or a file on your phone of what you've actually submitted in the mandatory reconsideration, so that if they do phone you without warning, you will have the ability to look back at what you said to confirm any points that they question. Now, if a person has submitted a mandatory reconsideration and they are still not happy with the outcome for any reason whatsoever, they can then submit an appeal to a tribunal, which is an independent tribunal that takes a look at the decision. Again, a claimant has 13 months from the date in which they received the mandatory reconsideration notice in which to submit a tribunal appeal. Again, you need to have a good reason if it's past 1 month. However, as long as there is that disability there, that is your good reason. However, in relation to submitting an appeal, once an appeal is started, you get put in the queue waiting for the appeal hearing to take place. At the minute, that appeal hearing queue is anything from 6 to 24 months long. It is a slow process. And I will be honest, it feels like not a lot is happening during that period of time. If you need to gather more evidence and more information to support your appeal, you can still submit information after you've lodged the appeal within that 6 to 24 month period whilst you're waiting for a hearing to take place. So if you are going to process an appeal, although you can lodge the appeal after 13 months, if you want to get the ball rolling and you want to get that decision put right, you're best to do it as soon as you can. Because otherwise, if you wait 13 months and then submit that appeal on the last day, you're then waiting another up to 24 months. You're quite a long way down the line and you're waiting a long period of time to get the decision overturned. However, it is really worth noting that in relation to both an appeal or a mandatory reconsideration, the DWP can only look at how you were in that 3 months before you started the original claim and then 9 months after that 12-month qualifying period, they cannot take into account anything that's changed, be that for better or for worse, after that period of time. As an example of that, if somebody is suffering from long COVID or neurofibrosis, for example, and then a couple of weeks, maybe, I don't know, 6 months, a year after the PIPP claim was processed, fell over, broke their leg, it's a totally unrelated injury. When you challenge the decision, they cannot take into account any impact from that broken leg. They can only take into account the way you were at the time of that original decision. An appeal can be lodged either online or by paper. If you are going to do it by paper, I've sounded like a stuck record, send it trapped. However, sending it by paper, it has to be manually processed by a person at the tribunal centre once they receive it, which adds even more time to the process. If possible, always submit it online, because that initial processing is technically done yourself, and it will get you in that queue for an appeal hearing much quicker. Once you've lodged an appeal, be that online or by paper, the courts will notify the DWP that you are appealing that decision, and in doing so, the DWP have to respond and give reasons why they believe their decision is still correct. At that point, they can either give those reasons as to why it's correct, or they may decide to make contact with yourselves, with the claimant, and offer to change the award, because they realise that it is not. Some people believe, and it's hard not to believe, that the DWP sometimes give a decision, stick with that decision for as long as they can, hoping that somebody will give up and not challenge a decision. Always, always challenge a decision if it is not what you expect it to be. So I mentioned that you wait for an appeal hearing. So if the DWP don't change the award and you have to wait for an appeal hearing to take place, these hearings can take place similar to an assessment by telephone, by video, or by face-to-face. And a claimant can have somebody with them for support during that process. Either connected in by video link, if it's a video, by telephone, if it's telephone, or in a face-to-face situation, the courts will sometimes allow a representative to be connected by telephone or video in that situation, unlike assessments that Kat mentioned earlier. The panel is made up of 3 people in relation to a hearing. You've got a judge, so that's a solicitor or barrister, who's overseeing what's going on, a medically qualified doctor, and a disability member, which is a person who themselves either have disability or significant experience caring for somebody with disability. They make up the decision unanimously. What generally happens is one panel member talks about daily living questions and one panel member looks at mobility questions in that case. It is possible for a judge to act alone without other panel members. However, in reality, that doesn't happen. The only time I've personally known that happen is during COVID, before they started putting in place telephone and video links, when they had to socially distance and keep the numbers in the room below. And again, that was only done in a small number of cases. During the hearing, it is really important to have all of your paperwork with you, which the DWP do send you after you start an appeal. That's what we call the bundle. Big, thick chunk of paperwork, which is everything to do with your claim. And generally speaking, the hearings are quite informal. It's quite conversational. People think of courts and they think of a judge with a big wig on and a big gavel, banging the hammer, people in a witness box. It's not like that. Tribunals are the most informal type of court process there are. It would simply be one table will have the panel members, and there'll be another table in front where the claimant and any companions would be sat. Nobody's in big wigs, big gowns, everybody's just in more clothing, much like we are right now. Average hearings last between 30 minutes and 2 hours. Some are shorter, some are longer. But if a person does need a break at any point because they've been sat down too long, they're too fatigued, they've been stood up for too long, whatever the situation may be, the panel will be very accommodating to those needs. Once the panel has asked all of the questions that they see the need to ask, they will go away, they make their decision, and in some cases they'll provide that decision on the same day, or if they're really busy, you'll have to wait for that decision to come out in the post. Waiting for a decision isn't a good thing or a bad thing. It's no indication whatsoever as to the outcome. It just is based on how busy the panel are and the courts are that day. If you've had an appeal hearing and you're still not happy with the outcome of the decision, in a small set of circumstances, there is an additional process that can be undertaken called an upper tier tribunal, which Kat's about to talk to you about.
Thank you. Upper tier applications are quite complex, and it's something that I look after within our organisation. It's a further chance of an appeal, a further appeal. However, this avenue is only available, as Chris said, in a limited number of cases, and it's only if it can be identified that the tribunal panel made what's known as an error of law. The only way you can find out if the panel have made an error is to, after the hearing, email the court within 30 days to ask for what's known as a statement of reasons and also the recording of the hearing. The statement of reasons comes out, it's a little bit like a long essay that explains exactly why the judge has made that decision. And generally you need to find somebody that knew the stuff with the law, because what you'd be looking for is what's known as an error of law. So you're looking for if the judge has applied the law incorrectly, if the proper procedure wasn't followed, if they didn't make adequate findings of fact or with adequate reasons for the decision, or took relevant matters into account. You cannot make an upper tier application just because you do not like their decision. You have to find somewhere that they have erred in respect of the law. There's a strict 1 month time limit from getting the statement of reasons to make an upper tier application. Usually you will make the application and they'll say, no, you can't apply to the upper tier. And then you'll say, well, tough, I'm going to anyway. So you do it anyway. But you do have to go through this process and it takes a really, really long time. Last year we were successful in every single one of our upper tier applications that we did. But they take about 2 years. So it's not something to be looked at lightly. What I would suggest is if you have had a hearing and you do not agree, and you think that they have made an error and you're going to get some advice on it, definitely appear and definitely start the upper tier application process. But in the meantime, get another claim in, because your claim will be decided quicker than the upper tier application will be. So it's better to run both processes at once. The obvious downside of that is the mental capacity and the mental bandwidth that it takes to be running both of those processes at once. It can be quite exhausting. Next slide, please, Chris. That brings us to the end. Just our contact details are there, and we have popped some leaflets on the table. One of the things that we do as a CIC is we run a free advice service. So if you do need any advice, you have any questions, please do feel free to contact us using the details on the leaflet or the details on the screen. That phone number is by WhatsApp, because we are a fully online service. We'd look to be able to afford to run a telephone line, but we just can't. So it's fully online service, but it is free advice if anybody's got any questions. On behalf of both of myself and Chris, I just want to say thank you again to Karen for inviting us today. We do appreciate it, and we are staying for the Q&A session, so if anybody's got any questions for us, please do feel free to ask. Thank you.